Welcome to this video on the basics of electronic discovery or e-discovery. One of the most important elements of civil litigation is e-discovery, right? So it's important to understand what the process is, especially as it relates to generally criminal matters, which have a much higher burden of proof. But civil litigation happens every day and in many, many different contexts. So it's important for us to understand what that is like and why it matters for uh, digital forensics and e-discovery. So discovery is a legal process in which each party involved in litigation is able to provide the other party rather, with evidence and documentation that it intends to use in its case. It's important to understand that discovery is really that opening exchange of documents and data that establishes the level of information that the parties have, and it's very important in civil litigation. Lawyers have an important discovery obligation under the Federal Rules of Evidence and the Federal Rules of Civil Procedure. In this case, this snippet here shows that failure to preserve electronically stored information, or ESI, because a party has failed to take reasonable steps to preserve it and cannot be replaced or restored, the court has many options, including to dismiss it in its entirety or to enter a default judgment for the other party. So it's pretty important to understand the obligations and be able to preserve evidence and present it to the other side. So what is e-discovery? E-discovery is the process of identifying, locating, preserving, collecting, preparing, reviewing, and producing electronically stored information. Now, what is electronically stored information? Well, guess what? We're going to get into that. But think about it in terms of everything that we have in our digital lives. So ESI is any information or record kept in a digital or electronic format, not kept in hard copy or paper format, and regardless of the original state, is electronic. Now, these are also sometimes can be referred to as digital native files or born digital. These are because that's the only place they exist, is in the electronic form. So ESI looks like all of these different types of data, whether it's databases, audio, video, documents, spreadsheets, PDFs, emails, servers, hard drives, mobile devices, social media, home and work computers, online shared drives, email files, online storage or cloud documents, document management systems, websites, metadata, copiers, USB drives, and so many more. And ESI changes daily. So it's very important to understand what it is, where it is, and how to get there. So in e-discovery, there are really three key things to think about. First of all is the initiation or the e-discovery plan. And this is where you identify the data, locate the custodians of those records, and move to preserve it. This is often called a litigation hold or a lit hold. And it's basically say, hey, this thing is happening. If you have information related to subject X, save it, right? We're going to be coming to get it. The collection can be digital forensics. It can be drag and drop. It can be a lot of different things. Then you need to be able to process it and ingest it into a review platform. The review platform enables the attorneys to then go in and document the coding. So, for example, if they identify that a piece of information is relevant but subject to attorney-client privilege, then they need to code it as such, and then we'll produce a log to the other party that says, here are the things we found. However, it's subject to attorney-client review, and we're not turning, or attorney-client privilege, we're not turning it over. So document coding and that review process is really, really important. Now, of course, the bigger the case, the more complex the case, this is where analytics and automated review comes in and is a big issue in e-discovery. And then, of course, you have to actually produce it to the other party, and that's really important. So in the planning phase or the initiation phase, think about what types of documents or data are needed. Where are they? Who actually controls them? How do you preserve them and retain them? And of course, depending on the volume, scope, timing, you may need to do specialized communication to those people. You may also need to document the process. In fact, you should be documenting the process because very often litigation disputes hinge on the documentation of the preservation. Collections are what specific files, locations, custodians, and data types are you needing? Are you doing self-collection of data? Are you doing active collection? Are you doing forensic imaging where we're bringing in digital forensic specialists? And then, of course, you have to process them through some form of review platform. And then, of course, review itself. Are they responsive? Are they relevant? Or are they privileged? This is where that TAR, technology assisted review, predictive coding, things like AI, right? It's all part of this. Training the review team and documenting that training is really important. And then, of course, you have to give a copy of giving that copy to the opposing party. So this is the e-discovery reference model, and it's really interesting because it talks about on the front end, the importance of information governance. So looking at your policies, your procedures, what plans in place does the organization have in the event that there is litigation. So actually preparing in advance for those types of requests. Of course, you have very, very high volumes of data in this phase. Same with identification, preservation and collection, then processing, review, and analysis, production, and presentation. And as you can see, the volume goes down, but the relevance goes up. And so there's this kind of Venn diagram of where our information is both voluminous and relevant. But at the same time, at the end of the day, you can't present it all. And you have to really think about what is the most important parts of the case for both sides. Understanding the skill set and the knowledge for e-discovery is really important. So obviously there's the legal process of civil litigation and what that all entails. There's the technical piece, which includes, but is not limited to, digital forensics. Project management is another key part of e-discovery because that's basically what it is. You're running a case, you're managing multiple stakeholders and multiple sub elements of that project. And certainly, of course, there is the ethical standards, and that is really important. So the case and legal context is really, a lot of these key questions need to be answered in this phase. So what are the underlying allegations or issues? legal context of the case, what are the elements of proof, and the current status, who is involved, what are the deadlines and timelines, and then thinking about the potential volume, scope, and types of electronically stored information. And certainly thinking about it from the perspective of the opposing side, what do they bring? What do they have? Who are they using? What expertise and issues do they have? It's important to tailor the technical solution to the specific case. This is really, again, kind of those project management skills come in really handy. Communicating the needs and expectations, the desired outcome, and the process are really critical to this. Thinking about which technical solution is the most applicable based on those answers. Being able to plan and organize effectively, but also document that process really lends itself to a much more defensible e-discovery process, because at the end of the day, sometimes the biggest fight isn't over the facts of the case, but how much information was provided and how it was provided. Again, with civil litigation, you're not looking at people going to jail. You're looking at money, right? Who is supposed to pay who? And that is why e-discovery is so big and so important. Knowing what options there are, what are you looking for in documents, the individuals that have them, and then how they're being collected, organized, and retrieved are all key factors in how you tailor your approach to e-discovery. Of course, there are ethical issues, competency issues. Look at the federal rules of evidence, the federal rules of civil procedure. If you're in a state, obviously the state. Also, things like the American Bar Association, model rules of professional conduct. They talk about competence for both the lawyer and non-attorney staff, and making sure that the lawyer is adequately supervising all of these people. Making sure that there's baseline training, supervisory elements, certifications, continuing education, just making sure that the lawyers and their staff and their experts are all really have that kind of baseline skill knowledge. Thinking about the benefits and risks associated with each piece of technology, but also making sure that they're complying with their continuing legal education requirements. So again, these are all really important factors in e-discovery. And of course, having really good policies, procedures, and standards. This is really important. Training and awareness of obligations, having a great case management process. Certainly, unique issues will present themselves. So, how are you going to handle those? What are those pieces? What do they look like? Of course, having a peer review process can be really helpful, and staying abreast of all the best practices or leading practices in e-discovery or litigation support. Sometimes you'll see e-discovery and litigation support kind of used interchangeably. Litigation support, of course, is much broader than just e-discovery, but that's preparing the case itself. So I hope this was helpful. I hope it was interesting. Again, it skims the surface, but gives you a sense that e-discovery is different because it's civil, and civil is very different from criminal, although there are always overlaps. But again, some of the issues are the same, but how we do it can be different. So hope you enjoyed it. Thanks for watching, and be well.